Video on ചെയ്തിട്ടില്ലേ? Respected resource person, Dr. N. Ajit Kumar sir, Dr. Sister Gisela George, Principal of Mercy College, Palakkad, faculty members and students, a warm good afternoon to all. With immense delight, I introduce you today's webinar on topic IPR, with special focus on patents and copyrights, hosted by PG Department of Economics and Sociology in association with Research Forum. Now, I would like to invite Sandra to deliver a welcome speech. A very warm good afternoon to one. A very warm good afternoon to one and all present and attending today's webinar on IPR with a special focus on patent and copyrights, organized by the PG Department of Economics and Sociology, Mercy College, Palakkad. First and foremost, I'd like to welcome our resource person for today's webinar, a renowned economist from Kerala, Dr. N. Ajit Kumar, retired principal of Cochin College, Cochin. Sir was a research guide at Devara College and has produced more than 30 PhDs and was also our Ligi Ma'am's research guide. Sir is a former secretary of the Kerala Cricket Association and is also a common face in many TV discussions. He is an active member of various associations. Yet another feather in his cap is that he has made blood donation for more than 100 times. Dr. N. Ajit Kumar has published a number of books related to economics and has served as a resource person in various national and international seminars. It is indeed an honor to welcome you, sir. Now, I extend a warm welcome, as always, a constant source of support for us. Next, I'd like to welcome Dr. Liji K.T., Head of the Department of Economics, and Mrs. Deepa N., Head of the Department of Sociology, to our today's webinar. I also extend a warm welcome to all our beloved faculty members and to all other participants from various institutions. Last but not the least, I welcome all students who are present and attending. Once again, a very warm welcome to one and all. Thank you. Thank you, Sandra. Next, I invite our beloved principal, Dr. Sister Gisela George, for the presidential addressing.
Good afternoon, one and all present here. I take this opportunity to congratulate the Department of Economics and Sociology for organizing a webinar on IPR, special focus on patents and copyrights in association with the Research Forum Arts. IPR is a very relevant topic in this era. Intellectual property rights are the rights given to persons over the creations of their minds. They usually give the creator an inclusive right over the use of his or her creation for a certain period of time. Modern scientific inventions are part of IPR. I believe that all the participants should make use of this golden opportunity and gain knowledge on IPR, copyrights, and patents. Let me conclude. Thank you. May God bless you.
Thank you, sister. Now, with pride and honor, I invite respected Dr. N. Ajit Kumar sir to take over the section. Sir, please.
Good afternoon, one and all. It's been a real honor for me to address you all for this session. As uh, Madam Principal made it very clear that IPR has become a very important item which every person should have a basic understanding about. Intellectual property rights. That's what IPR stands for. And I'm also happy that the institution has decided to focus on two of the four types of intellectual property rights. In fact, intellectual property rights, at the outset, I would like to tell you, my dear listeners, are of four types. The first is copyrights, the second is patents, you have trademarks and trade secrets. First, we'll overview all these four and then go forward. Yes, my focus is going to be patents and copyrights. Now, what do you mean by a patent? Patent is something which has been in existence for quite some time. It's not something which started yesterday or day before. Long time. Right from the 17th century, patents have been in use. What is a patent? This is something which we all make use of in our day-to-day life. You might have even heard politicians saying, that is his patent word. Certain words used by politicians are misrepresented. That is his patent. That means patent is something which is exclusively given. The right of use is exclusively given to a certain person or a certain institution, as the case may be. It would be mainly for an invention, or it may be for the introduction of a new product, or it may be for bringing about a new type of business organization, or it may be for introducing a new type of marketing. All these are patented. So when a person is given a patent, it means the use of that is exclusive for him and nobody else can use it. A patent can be used only by the concerned person who has brought about something new. It is something new, my dears. Some new item has been introduced. That belongs to that person. Nobody else can use it. If anybody else uses it, what is important? He has to pay a royalty. So that is how patents were introduced. When I think of patents, I normally give a very good example, which I hope you, my dear students, will be able to understand. Way back in the 19th century, when development started in a big way in Europe, a man called Alfred Nobel, not Alfred Marshall, Alfred Nobel. Alfred Marshall is familiar to all students of economics. Alfred Nobel made an invention called dynamite. He introduced it, you know the reason. You know, Europe at that time was highly full of hillocks, hilly areas. To enable the removal of these hills, to make passage easy, that was the idea behind the great Marshall Nobel introducing this thing called dynamite, for which the British gave him a patent. He was very happy. It was a good patent. He was very happy with it. In 1870, there was a war between France and Germany, 1870. Now, do you know what happened? In this war, both the French and the Germans started using dynamite for destructive purposes, for killing each other. Dynamite was used for war in the year 1870 to 71. In the Franco-German War, dynamite was used for destructive purposes. But for the use of every gram of dynamite, Nobel received a royalty. And overnight, Nobel became a very, very rich person. Hello? There seems to be a problem.
Yes, sir. Yes, sir. Okay.
Hear me, is it not? There seems to be some video.
Jay, sir. അതെ സാറിന് ഞാൻ മെസ്സേജ് ചെയ്ത് നോക്കട്ടെ. എല്ലാരും കേൾക്കുന്നുണ്ട്.
Now it's okay. I'm sorry, dears. I think there was some video issue. That's it.
Okay, sir.
Now
Okay.
it's okay.
Okay,
Now
okay,
listen.
sir. Okay.
Sorry for the interruption. I hope there won't be further.
No problem, sir. Okay.
So dynamite was used for war purposes, my dears. And when it was used for war purposes, Alfred Nobel received huge royalty. And he didn't know whether to be happy or sad. To use his words, I have made a rich, I am given to Alfred Nobel for dynamite, the misusing of that item, giving Nobel huge amounts of money. The entire money was transferred by Nobel to institute the Nobel Prize. That is a patent. I hope you got the idea. Patent means that I'll discuss patents a little more. First, I thought I'll introduce the 4 items. This is a patent. Something which is normally an intellectual it's an intellectual property. It's an intellectual property. It is not, I should say, intangible. It can be felt. What do you mean by intangible? Something which you cannot see, but which you can feel. That is intangible. It's not tangible. It leads to tangible goods. It's an idea. It's an invention. It's something which he alone had the right to use. And if somebody else used it, he has to be given a royalty. This is a patent. And normally patents are associated with those commodities or I should say those inventions which lead to the production of commodities. And here in our subject of social science, which is important for both sociology and economics, which I'm glad that there is a nice synthesis of economics and sociology here, because the relevance of both, I can bring it out. Yes, an economic requirement is an invention, and innovation is a sociological aspect. Society requires it. When an invention is made, it's a good thing. A good invention takes place. And the person who makes an invention is very happy about it. But the benefit society will get is only when we make use of that invention. So you get the point. So a patent has got its advantages, and patents are a good means of encouraging people to find something new. They can find something new. If you find something new, you can get a patent. And getting a patent means it's a great honor. And patents are not that easy to get. There are a large number of regulations that you have to follow. Lot of norms are there. Persons of high reputation, persons of high credibility They are the persons who evaluate, and then they decide, yes, this particular item can be given a patent. And a patent, my dears, is only for a specific period of time. Normally, 5 to 20 years, depending upon the country. In India, it's 5 years. After 5 years, you have to renew your patent. You just cannot continue. You say, this is my patent, nobody else can use it. No. At the end of 5 years, an evaluation will take place. If things similar to that have taken place, and if there is no improvement in what has been given, and most importantly, if the patent has not been made use of for industrial purposes, it ceases to be useful to people. Why should you give him a patent when he has kept the patent and kept it at home? He has not used it. Nor another thing, my dears, a person who has a patent is expected to reveal to the public the information which he thinks is ideal for everybody to know. How did he develop this? What was the inspiration behind the commodity or what the invention? What were the things that he made use of? Then only a patent will be useful for development. So that is it. So patent has got such a dimension. A dynamite is a patent. I know of a teacher of mine. He developed an invention from which the invention was fantastic. Electricity could be generated from waves. Now we are talking of wave energy. This man developed it in 1978. Now nobody heard about it. Why? He did not make use of it. He received the patent for 5 years. In the 5 years, he should have used it for industrial purposes, whatever it may be. What is a copyright? So now I hope, my dears, you've got an idea about what is a patent. Now, what is a copyright? Copyright is different. We can't keep patents and copyrights on the same pedestal. We normally say that. Copyrights are a legal right given to originality of a work. When an original work takes place, a legal right is given to print, publish, perform, or record that work. Now, for example, Lata Mangeshkar, you know, she is the Nightingale of India. Unfortunately, being a senior citizen, I have a tendency to give examples of that nature, my dears. You have to forgive me. But I'm sure everyone listening to me is very fond of Lata Mangeshkar. Lata Mangeshkar's songs is something which nobody will say is bad. Yes, of late, her songs are less because of aging. Mohammed Rafi, Kishore Kumar, they are the masters of the old. Both Rafi and Kishore Bhai are both no more. But Lata Mangeshkar and her sister Asha Bhonsle are very much in the fore. They have been singing for years. Lata Mangeshkar, you know, has completed her diamond jubilee of singing. So much. But the amusing thing, my dears, is her songs she would sing. And what does she get? Nothing. She will get paid for whatever the people will do it. And now what happens? This song is sung by others. For what? For profit. For making money. How is that? Performances are given. I still remember on the 30th of August every year. That's the day the late Mohammed Rafi passed away. We have a fantastic program here in Cochin. I'm speaking from Cochin, where the songs of Mohammed Rafi are sung without any hesitation, and one ticket to enter that auditorium on that day costs 1,000 rupees. That's the minimum. Being a Rafi fan, I normally attend. 1,000 rupees is the ticket. You can very well imagine the amount of money which the organizers were making. And what happened? This was going on. Well, this was brought to the notice of the government. Now, this is something not restricted to India alone, my dears. It's an international issue. So WTO, the World Trade Organization, decided while inventions, discoveries, etc. are patently protected, there is no protection for music, dance, artworks, etc. There is no protection. Anybody can copy them at any time. Books, no protection. Anybody can copy from another book. You write a book with great difficulty. It's a personal experience of mine too. I wrote a book with great difficulty, using all my efforts. And one fine morning, another person introduces the same book on the same topic. And when I just checked that, he found he had not even changed the dots and the commas. The full stops and the commas he had not changed. Verbatim. What could I do? I was helpless. Because there's nothing to protect me. There's nothing to protect me. This was a major issue, purview of similar to patents. Earlier, there was one system which I would like to inform you. A person who wrote a book could give the copyright to a publisher, and the publisher can protect the person. But then the person who wrote the book has no control over it. It's the publisher who has to do everything. And after a certain period, there was no value for the contract also. Absolutely no protection. But with TRIPS, proper copyright law came into being. Now, if any original work is copied, what happens? The concerned person can move against the person who has copied. Secondly, the person concerned has to get, if a person now, for example, in our Rafi night, now what's happening is, thanks to TRIPS, a portion of the money collected is given as royalty to the family of Rafi. Royalty has to be given for performances, music, dance, anything. We normally say that literary, artistic, educational, and musical material have all been brought under the copyright law. Today, copyright is associated with, without any hesitation, I can tell you, a type of patents which is useful for what the person concerned. Now, you now take, if we now or any one of us thinks of making use of a song sung by one of our maestros for money, of course, for in competitions, etc., if you sing, there is no problem, where no money is involved. But if you sing a song of one of the maestros for money, then you are obliged to give the person concerned or his family what? Royalty. Royalty is mandatory. The other day, my dears, I was traveling with my friend, and he kept some music. He put on his music player on. The cassette was used. And the songs of Yeshudas started. Beautiful it was. So I just sent, because another great, I'm also a great follower of Yeshudas, said, this person is singing Yeshdas songs very well. I proudly said that because I knew the songs were being sung by somebody else and not by the great Yeshdas himself. Then immediately my friend took a little, was very annoyed. Who said this is Yeshudas himself who has sung? And I told him, please don't tell me that. It's not sung by Yeshudas. It's sung by somebody else. Then he immediately took out the cassette and showed me. Do you know what it was written? Yeshudas Padiya Paatugal. Below, copyright. Copyright has been taken by somebody else. Copyright has been written there. So the copyright of those songs were purchased by this person from Yeshuda's family. And he converted it into a cassette. And now he's making money out of it, for which he has given the family royalty. This is copyright. If you want to make use of somebody else's work, somebody else's creative work in the field of, these are the 4 areas which I would like to tell you, littered by copyright. This is copyright. So patents, copyrights are entirely different. Authors of books, songs and artworks, nobody can copy them. And the duration of a copyright, now you ask me, sir, what's the duration of a copyright? Will a time come when we can make use of this without paying? Yes, my dears. The duration is not much. The duration of a copyright expires 50 to 100 years after the death of the creator. I repeat, 50 years after the death of the creator. Now, for example, 1980, the great Muhammad Rafi passed away. After 2030, you can use Rafi's songs without making any payment. But till 2030, you are obliged to make a payment to Rafi's family if you make use of his songs for commercial purposes. So that is copyright. Now, certain books are written by authors. Recently, I had a very amusing incident, something which I saw. My Experiments with Truth, written by the great Mahatma Gandhi. Gandhiji published that book in the year 1940. In 2015, in fact, that copyright was for a period after Gandhiji's death. Now, Gandhiji passed away in 1948. Till 2018, the copyright of that book was in the hands of the Gandhi family. But now 2018 has passed, 70 years are over after the death of the great Mahatma. That book can now be republished by somebody else. Now we can make use of it and do research on it. We can make, of course, research we could do, but we can make use of it as part of our books. Earlier we could not do that. So that's it. So copyright ceases to exist or expires, the duration of a copyright expires 50 to 100 years after the death of the creator. So that is how copyright is different from patent. Now you saw the difference. Patent and copyright are not the same. Patents are normally, I told you, for inventions, for new things, for new discoveries. And the primary goal of patent is to promote inventions. You know, when you have got the incentive that what you invent will be your own, and if you give it to somebody else, you can get some money out of it. That's a big incentive. Is it not? It's a big incentive. And patent law was actually introduced in Britain with the sole intention of promoting patents. Promoting inventions. And that's exactly what happened. Introduced in the 17th century. That's what I'm given to understand. It was in the 17th century. I'll get to give you the, no, actually the patent statute was in the 17th century, the patent statute was introduced. And without any hesitation, I can tell you, my dears, this patent statute introduced in the 17th century was primarily responsible for the Industrial Revolution. I'm sure many of you have heard about the Industrial Revolution. New generation may not know fully about the Industrial Revolution. Between 1750 and 1830, there was a spate of inventions all over Europe. A spate of inventions. And the main reason why inventions were in such large numbers was the possibility of getting patents. Now you'll ask me, how come these inventions? With a very simple example, I can help you understand it. Prior to the Industrial Revolution, Europe faced an agrarian revolution. This cotton has to be converted into thread. And what was the method used at that time? It was the labor-intensive method of the cotton being, this was the way. You will go on pressing the cotton with both your hands for a very, very long time, and slowly the thread gets created. The amount of cotton which came about was so large, it was a good bumper crop for the farmers. But the farmers suddenly realized that when there is so much of crop, where is the possibility of it being used? Because to convert the cotton into thread, labor-intensive methods are being used. And what happened, my dears? Immediately after the cultivation, it started raining. At such times, in Europe, they did not have facilities like having godowns and warehouses. They were very few. So the entire crop used to get destroyed. And the farmers were in a very, very bad shape. The British government said, is anybody willing to bring forward any invention which would enable the conversion of this cotton into thread? Such a person will be given a patent. And the patent, if it is used by anybody else, you will be given royalty. Yes, this was the incentive offered by the government. Immediately the scientists started thinking about it. And one of the scientists came out with this, what is popularly called the spinning jenny. The spinning jenny. James Watt came out with the spinning jenny. Or Arkwright, I think. Sorry, James Watt is that is something else. Arkwright came out with the spinning jenny. The spinning jenny would convert this cotton into thread like a machine. It was a machine which was evolved. He was given the patent. He was so happy, thrilled. He started a manufacturing unit, and a good number of these spinning jennies were manufactured, and the problem was sorted out. The cotton cultivators were benefited. Arkwright also was benefited. There was this sign of industrial progress. What was responsible? Patents. See the role of patents. So the patents have this dimension. Copyrights, the dimension is different. What is used for a copyright is different from a patent. The two are not alike. I must make it very clear. I hope by now the fact that both are not alike should be clear to you. Now there is a third aspect. I thought along with this I should discuss those two things also. Trademark. I'm sure you're all familiar with that. In fact, that is the most important type of IPR. In my feeling, the most striking IPR is trademarks. Each product has a trademark. Haven't you noticed? Only that product can use it. Nobody else can make use of it. It is unique. Now, Oppo. I'm using an Oppo. Behind it is written OPPO in a very particular manner. That is something unique. That's their trademark. Every commodity has its own trademark. And I'm sure you've seen that. That is also an intellectual property. It is something unique. Nobody else can use it. Nobody else can use it. If something similar is used, immediately there will be problems. I'll give you an example. You know, to play a lot of cricket. I think somebody was telling in the introduction, they told me about my role in playing cricket. I used to play lots of cricket. In the evening after my game, after my practice, I would come back home and they use this Lifebuoy soap, which was so nice. It was very popular. Now, do you know what happened? Nirma company, they came forward with another soap, same color, everything, and they gave the name Nirma Boy. Lifebuoy, Nirma Boy. So what happened is, the color of the soap also was similar. And you know, at such times, the ads and the advertisements, etc. were limited. Television was not existing. So there was no question of finding the difference. So certain persons would go to the shop and say, give Lifebuoy. That person, well, Lifebuoy is not there, Nirma Boy is there. Give me any boy, you take it and go. Just see the misusing of a trademark. Immediately, the Lifebuoy went to court. The court ruled in their favor, saying that that's how it's from that particular judgment that trademarks became important. And today, trademark is an intellectual property. A trademark can be used only by the concerned organization for whom this trademark has been given. It is mandatory. It is also similar to patent and copyright. In that case, there is another difference. In patent, it's for 5 years. Copyright, 50 to 100 years after the death of the author. Here, it is permanent. Nobody else can make use of it unless the company concerned closes down, stops production, and transfers it to somebody else. There is no law which says that trademark can end on a particular day. It's permanent. Nobody else can use the trademark. A mark used by one person, no other person cannot use it. That's why, you know, this designing has now become a very, very important occupation. Designing. What are you doing? I just asked one of my colleagues, what's your son doing? He's studying the National School of Designing. What do you design? Marks. Why? For companies. And companies use it exclusively for themselves. Because it's also a part of intellectual property. And you have also what a thing called trade secrets. A trade secret is something different. A company which is in charge of a trade secret has patency in that. Nobody else can make use of it, whether you like it or not. We have an interesting incident about trade secret also, which I would like to share with you. In the 1970s, my dears, the most popular drink was Coca-Cola. Not the present Coca-Cola, the old Coca-Cola. Very popular. Now they are the trade secret. And they captured the entire market. The entire market was in the hands of Coca-Cola. We used to say, children in the Rajasthan deserts had not seen rain because for 5 years it did not rain in Rajasthan, but they have seen Coca-Cola. So well the Coca-Cola system was distributed. In 1977, after the elections took place, the Janata Party headed by Mr. Morarji Desai came to power. And we had George Fernandez. I am sure you must have all heard about him. He passed away recently. He became the industries minister. He found that Coca-Cola was transferring a huge part of its wealth that it was accumulating in India to its mother country, the US. Fernandez didn't like it. He said, he gave them 3 options. 1, either allow partnership of another company in your company. 2nd, give us your trade secret. Third option, get out. Coca-Cola preferred to get out than give the trade secret. It's a very famous, patents as such, a right that is given. We normally say that the country where the patents arose is England or Britain to be exact. And I also told you the reason why the British gave a lot of support to patents, so that the patents could lead to more inventions and more development. Copyrights. Copyrights have had a very, one can say without any hesitation, a fluctuating career. It is after the coming of TRIPS as such that copyrights became very popular. I'd like to give you one more example about copyrights that will help you to understand the concept still better. Frankly, copyrights began with books, where original authors found their works were being printed and published without their permission, which your sir also has faced. They were printing and publishing things without permission. And what was happening is, you know what they will do? That was another, in the olden days, that was another interesting thing. Books are normally in different types of editions. You've got what is called the hardbound edition, you've got the library edition, and you've got the paperback. Now, a publisher will publish in whatever edition he wants. So, X, let us assume, published a book in hardbound edition, or in a library edition. The price is more for hardbound and library. Do you know what happened? A very smart fellow used the same book, took out a paper, and made it paperback and started selling. Nothing could be done. I have not copied. This is paperback. Paperback is much cheaper than both library edition and hardbound. I still remember a book of mine was library edition was 175 rupees. I'm talking of the days of old. Now I don't publish. 175 rupees was the library edition, and the paperback was only 50 rupees. You see the difference? Now, at least in this case, my publisher had control over both. What if my publisher had no control? Somebody else converts it into paperback and starts selling it. What will be the loss? The loss is too much. Because all these factors which prompted the coming of copyrights. Copyrights had to be introduced one day or the other. And we are really very happy that the WTO took the initiative. Now, India had its own copyright law. But 1995, WTO came into being. And from the 1st of January 1995, the day it started functioning, the copyright law came into being. TRIPS was introduced in 1995 itself. India, is one of the founding members of WTO. One of the founding members. 119 countries signed the WTO agreement in April 1994. And the first agreement was regarding TRIPS, and that was related to copyright. So with that, what happened is, India had to make some changes in its own copyright laws. A lot of copyright laws were present in India, but there were no laws to protect, as I told you, the 4 areas which required protection: literary, artistic, educational, and musical. There were no areas to protect that. So that became essential. So to protect those areas, that's what I find India brought in the necessary changes. In fact, the record shows that the Copyright Act of 1814 was relevant in India at that time, 180 years back. Copyright Act of 1814 was relevant in India. But in 1995, with the coming of the TRIPS, India's copyright law also is very firmly and properly set. So in the present context, now I'm coming to, in conclusion, what should I tell you? Both patent laws and copyright laws are working in a most systematic manner. Any person can, without any fear, go forward and do a publication. He has nothing to fear. he is really well protected. And in the field of art, in the field of music, in the field of literary activities, in the field of artwork and educational activities, a new methodology is developed by a person. That methodology is his or hers. Nobody can take it. If you take it, it has to be on the basis of a royalty. It is true. The only place where nothing has happened is teaching methodology. I always tell my friends, teaching methodology is something which has not come under the Copyright Act. The way in which one person teaches, certain people have a tendency to copy it. Frankly, my dears, I am copying my own dear father, who was also a great professor. His methodology I am teaching. If I am speaking to you in this manner and in this way with examples, etc., it was he who told me. That's how you should tell them. So students will be able to understand your concept better if I give you examples rather than just giving you a big theoretical explanation. That's what I told your dear teacher, whom you again introduced as my own dear student, Gigi, who I told her, I'll give a good number of examples, which I hope your dear students will be able to understand and realize correctly the difference between what is a copyright and what is a patent. And patent and copyrights, without any hesitation, my very dear students, is the integral part of intellectual property rights. So IPR means what? Protecting inventions, protecting music, protecting the music composers, protecting the musicians, protecting so many persons who would have otherwise been totally neglected. They have been removed from neglect and they have been given the recognition that is due. In that respect, IPR has great relevance, and I'm so happy that Mercy College, which I know I have sweet memories of coming to Mercy College. I came there about 3 or 4 years back. I have sweet memories of coming there. I'm glad that the college is taking so much of initiative on such an innovative subject, something very innovative. And in that way, you also can patent this, saying that IPR is our patent. So if anybody uses IPR, this is our patent. Don't use it unless you get permission from us. Thank you.
Thank you, sir. Thank you, sir. Now I call upon Karishma to deliver vote of thanks. Good afternoon to each and everyone. Today, I would like to take the opportunity on behalf of PG Department of Economics and Sociology, Mercy College, Palakkad, to thank Dr. N. Ajit Kumar sir for taking time out of your busy schedule and being with us. Thank you for enlightening our views on IPR by giving special focus on patents and copyrights. I'm sure that it was a very informative session for everyone who took part in it. Next, I would like to thank our beloved principal, Dr. Sister Gisela Joy, thank Dr. Lijay Katie, Head of the Department of Economics, and Ms. Deepa N, Head of the Department of Sociology, for providing us with wonderful opportunity to expand our knowledge horizon. I would like to thank all the faculty members and participants from various institutions across Kerala for all your love and support. Also, I would like to thank all the students who participated for your full cooperation. Once again, I thank each and everyone who participated in the session. Thank you.
Okay. I'll sign off.
Hello. കേൾക്കുന്നുണ്ടോ? കേൾക്കുന്നുണ്ട്. സാറ് ലെഫ്റ്റ് ചെയ്തു അല്ലേ? ഓക്കെ, അപ്പൊ പിന്നെ നമുക്ക് കഴിഞ്ഞില്ലേ?